Hello, my name is Dr. Jackalyn Rainosek, and I'm with DTP-Leadership Group. But this is Hot Topic Bold Talk. And I am so delighted to have Richard Wilson with me today because he's the expert in the legal aspects of it. And I have experience in dealing with individuals that are a part of this case as a therapist and as a coach and so forth. So we're going to combine our knowledge bases. But one of the things, Richard, that I think about this case, and you can give the name and so forth, and what's going on in a minute. But one of the things I notice about this case is it's complex because it has two parent groups that are being concerned about a policy and procedure in the California school district. And you can go into that more if you'd like, but what I'd like to say, just from my perspective, not as a lawyer, but as just someone that works with these groups, is that there's a set of parents that simply say, I just want to be included. And by the California policies and procedures, you say you're protecting my child by not telling me that they are having gender issues. Now, gender dysphoria is what we're going to be talking about, and it is more complex and it is a mental illness. So we're going to be talking about that later on because it creates some dynamics. But I think there's one set of parents that just simply say, I do want to participate and I want to see if I can get help for my children and see what is the best for them. The other is a group that I've experienced many times, which is extreme religious groups that make decisions about what is right and wrong. And then they want the right to know when their child is having gender dysphoria because they're trying to counter what is happening. So, as a mental health professional, I just wanted to start with that. But I want you to explain the case and take as long as you want because, Richard, there's so many things to it. But I think it's a terribly important case. So your
Thank you.
turn.
Thank you, Jacqueline. And I will leave the mental health discussions and issues to you. My focus is to discuss the legal issues. And you told me I could give the name of the case. The name of the case is Mirabelli versus California. And specifically, what we're focused on today is an interim order that was entered by the United States Supreme Court in the Mirabelli case, not the decision by the underlying district court in California that tried the case on the merits and made a decision. And in Mirabelli, it concerned a California regulation or rule by the California Department of Education concerning informing parents about um, their children's gender decisions at school. The schools were directed by the state to honor the choice of pronouns and how the children wanted to be treated by the school from a gender standpoint, but teachers and administrators at the state schools under this regulation, as it's recounted in the opinion or the order, were not permitted to tell the parents about it. And actually, the starting plaintiffs were a couple of teachers that filed suit against the state because the teachers did not want to have to follow this regulation and not tell parents about these decisions by their children and what their children might be expressing to the teachers and others at the school. No, you're correct. Ultimately, you had sets of parents that joined in, and from a legal standpoint, the challenges were that this regulation that the California State Department of Education wanted the teachers to follow violated what are called substantive due rights of both the teachers and the parents. And some of the parents, but not all of them, also allege that this regulation violated their First Amendment freedom of religion right set forth in the Constitution. Now, again, I'm not discussing the underlying case at the district court, but what I will say is the district court, after trying the case, entered a permanent injunction. An injunction is a form of legal relief. It's actually equitable relief where one party is ordered to do or refrain from doing something. And in this case, to summarize the injunction, the judge, after finding that this regulation violated certain constitutional rights, ordered the California Department of Education to not prohibit the schools from informing parents about gender decisions that children made at school, so that the parents, if they asked, the school was required to let them know about these issues. And again, that the focus here was a legal one. Now, to the particular order we're discussing, that was handed down by the United States Supreme Court. And what the Supreme Court did was, after the case was appealed to the Ninth Court of Appeals in California, sorry, we got a lot of courts here. You got the district court, and above it, you've got the intermediate, the numbered appellate court, the Ninth Court of Appeals in California, and above all of that, you've got the United States Supreme Court. So California loses at the trial court. They appeal to the Ninth Circuit Court of Appeals, which is a federal intermediate court, also located in California, but its geographic region includes other states, Oregon and Washington. The Ninth Court said, well, until we're able to decide this appeal on the merits, we're going to keep the injunction from going into effect. So that happened by a couple of judges at the Ninth Circuit. And then what the plaintiffs did was they said, okay, well, we're going to ask all of the judges at the Ninth Circuit to decide this issue, but we're also going to ask the Supreme Court of the United States to put the injunction back in effect. And the order we're talking about was the Supreme Court of the United States saying, well, while this works its way through the appellate courts, we're going to put the injunction back into effect. We're going to require the schools to inform their parents about gender decisions of their children made at school while we decide this on appeal and while the Ninth Circuit decides this on appeal.
Okay, so Richard, I'd like to interject something here because I think this would be a good place to put it. One of the things that I read in the case itself is they bring up the issues of child abuse and use of child abuse laws and procedures and so forth. And we're not going to get into all of that, but I want to mention this because I think it's very important. One of the reasons that the schools did not want to tell and were protecting the rights of the children to express themselves in the way they felt themselves to be a specific gender, it was a way to support them in the process of making the decisions and have the schools support it. I think too that people have to understand that sometimes these procedures are put in place because they've had the experience of abusive actions taken by parents, and then the children don't get better. They have issues. Now we have a case, part of this case, where one of the children tried to commit suicide. Now we don't have all the facts about it, so as a PhD, I can't say all of it, but I can give hypotheticals. I don't want to go any further into it right now. I do want to talk about it later. But what I want you to do, because I think it's very clear, we have three levels of cases, but there's some other things that are happening. I want you to describe the shadow docket. Once you finish that, then I may have some comments. Then I want us to go to how the Supreme Court grabbing this now you may address it then, has removed the opportunity for the California procedure to stay in effect until there was a final decision about it. So I don't know if that's separate from the shadow docket or it has to be included in it. But
It
I personally don't like the shadow docket, and so I'm going to give it to you because you're the lawyer anyway.
okay, and it's included in it, but let's just start with what is the shadow docket. The term shadow docket, as I understand it, was coined by a University of Chicago constitutional law professor about a decade ago. And what it refers to is a part of the Supreme Court's docket in which people apply to the court for emergency relief. They ask the court to do something now because if you wait too long and decide everything on the merits, it will be too late. Um, the term shadow docket has been used by a lot of constitutional law scholars to refer to this emergency docket the court has. In fact, there is one constitutional law professor, a gentleman by the name of Steve Vladeck, who has written a book that was a New York Times bestseller in 2023 focusing on the shadow docket. So obviously, if you can have a book of several hundred pages about it, it's a topic that we can really only briefly skim the surface on.
Right.
But the issue or concern with the shadow docket is the court can make decisions which really can appear to have a far-ranging effect, and it can do so without fully explaining itself. And in the old days, I'll say the old days, but I found a statistic to illustrate this. It used to be that pretty much the only cases you would hear about on the so-called shadow docket were when you had prisoners that were on death row and they were seeking a stay of execution, something to prevent the state from putting them to death while a constitutional or due process issue was considered by the courts. When I was in law school and in the early part of my legal career, those are really about the only cases I ever heard of
Yeah.
on this part of the court's docket. And there are statistics, I think it was the Brennan Center for Justice where I drew these statistics from, point out that the shadow docket has grown exponentially, in particular over the last decade. And here's the statistic I'd like to share with everybody. From the year 2000 to 2016, so basically taking the entire two terms that George W. Bush, the 43rd president, was in office, and the entire two terms that Barack Obama, the 44th president, were in office, you've got one Democrat for 8 years, one Republican for 8 years. In that 16-year period, the executive branch of the United States government only filed 8 applications for relief under with the U.S. Supreme Court in the shadow docket. No, I'll point out that Mirabelli is not the president of the United States, the executive branch asking for relief. This is private litigants. But the reason I'm bringing these statistics to your attention is in the same way that this docket has grown with respect to the executive branch asking for emergency or temporary relief, it has also grown with respect to private litigants seeking emergency or temporary relief. So here's the illustration of how much it's grown. During the first term of President Trump, the 4 year period from January of 2017 through January of 2021, the executive branch filed 41 applications for relief on the emergency or shadow docket. So you went from 8 applications in 16 years, or one application every 2 years, to 10 applications a year during the first term of Trump's presidency. It slowed down, but not that much during President Biden's presidency. Over that 4 year period, you had 19 applications for relief on the court's shadow docket. So that's still roughly 5 a year compared to one every other year uh, in the second Bush and the Obama presidencies. And for the past year, from January 20th of 2025 to through January of 2026, there were 34 applications for relief filed on this docket in the United States Supreme Court. So you went from one every other year to 10 a year to 5 a year to last year, 34 applications. And,
Right,
and that,
right,
again, what that illustrates is you went from simple stays of execution to a large number of applications being filed with the Supreme Court where you're asking the court to do something that's temporary while the real issues are decided on the merits after full briefing and full consideration, either at the Supreme Court or at an underlying court. And the dissent in this order, the Mirabelli order, that was written by Justice Kagan really kind of focuses on it's a form over substance issue, but some would argue that actually it's a using form for substance issue. For instance, um,
wait a minute. I want to ask you something before you go into that. What
sure.
do you mean by substance issue?
Uh, well, okay. Let me illustrate this. The If you remember, several months ago, we discussed the National Guard case out of Illinois.
Right,
That was a case that was decided on the emergency docket or the shadow docket. What the court said is, after the court in Illinois said, we're not going to let you use the National Guard to enforce the laws here, the executive branch said, wait a second, we want you to stay that order so we can use the National Guard. The Supreme Court, in that case, in an interim decision, said, no, we're not going to allow this. And the point
right,
that I would make is that National Guard case from Illinois, the order was 25 pages. Now, I think, what was it, last month we discussed the tariff case.
right,
Um, as I pointed out to you, and as you lamented, that decision, counting all of the opinions by all of the judges, was over 170 pages. And
right,
that's what I mean by the merits, is you're considering the entirety of the case, and the
okay,
end result is you're dealing with a lot more and you have a greater level of explanation to kind of tell the reader not just this is what we're doing, but here's why we're doing it. And to
right,
illustrate the extreme of that, let's take the tariff case at 170 pages. Prior to the Supreme Court reversing Roe v. Wade with the Dobbs decision back a couple of years ago, Texas had passed a law outlawing abortion in the state. And the district court had said something to the effect of, we're not going to allow this law to go into effect. It's unconstitutional. And ultimately, the Supreme Court, in a one sentence order on the shadow docket, said the efforts to deny the law from going to effect are, we're not going to permit it, or it's denied. There was no explanation. There was a one sentence order that basically said, we're going to let the Texas law go into effect, even though at that time, before Dobbs, the law would have violated Roe v. Wade. And what a lot of people have pointed out was in that one sentence order, basically the court said, here's where we're headed, this is what we're going to do. But it was one sentence in which the court allowed that Texas law to go into effect. So, getting back to your question, what I'm talking about with form over substance is you look at the full decision, whether you agree with it or not, in the Dobbs case, where they discuss here's why we're going to do what we're going to do. And that was after that case had made it all the way up to the United States Supreme Court. What happened with the Texas law going into effect is that never got to the U.S. Supreme Court. What the Supreme Court did was it stepped in and kept a lower court from blocking that law from going into effect. That is the form issue of
Right.
this, in that
Right.
we're going to step in before everything has worked its way to us, and here's what we're going to do. And Justice Kagan points that out in the Mirabelli case in particular, and I think it gives a good platform to discuss the form issue, because what had happened, as we mentioned, the trial court said, okay, I'm going to enter this injunction. And then the appellate court over California said, well, we're going to hold off on letting you do that while we decide this
Right.
case on the merits. Well, the next step in this process, if you're following form properly, is you go to the Ninth Circuit Court of Appeals and you ask the entire court, not just three judges, but the Ninth Circuit Court of Appeals, I think it currently has something like 28 circuit judges and one chief judge. So you're asking all 29 judges to weigh in on this issue and decide whether or not the injunction can stay into effect. So what
Right.
the plaintiffs did was they asked the entire Ninth Court to do this, but at the same time, they filed this application for emergency relief with the Supreme Court. And what Justice Kagan points out in her dissent is she says, look, you've decided to jump the line. I think that's the actual phrase she uses.
Right.
Rather
Right.
than letting the Ninth Circuit decide this issue en banc, you've decided that, okay, we're going to go ahead and get involved. And in doing this, you're telegraphing where you want to go without fully explaining it. And what we really ought to do is let the Ninth Circuit have a bite at the apple first before we jump the
Right.
line. Again, I think that was the phrase she used, and take this issue on. Let's let it work out the way it's supposed to. And she actually cites a Supreme Court rule for how these things are
Yep.
supposed to proceed. And that's the shadow docket, is this practice of the Supreme Court making weighty decisions that are interim and that are supposed to not have effect and not be binding precedent, but nonetheless, it is taking on these big issues that arguably are not entitled to emergency relief before that court. And again, the line used by Justice Kagan is the court jumps the line, preempting the Ninth Circuit's normal and notably reflective en banc process. So that's what I mean by the form is,
Okay.
and ultimately Justice Kagan says, or she indicates in her dissent, that that she very well may agree on the merits. She says elsewhere in the dissent that um, none of this is to say that the court gets the merits wrong here. It may not, as to the plaintiff's free exercise claim or their due process claim, or both. Um, I have no doubt the parents have rights, even though
Right.
unenumerated, concerning their children and the life choices they make. So it's almost as if she's telegraphing, I agree with you on the merits, but we need to wait in line and let this case come to us fully.
Right.
And this gets to an issue I know that you addressed with me. Justice Kagan also points out that if the court really wanted to take this on the merits and decided in a manner where it will have a precedential effect, where you will have something to guide courts going forward that they can cite and rely on, that there is a case out of Massachusetts, the Lowell School District case, where the plaintiffs in that case, or the losing party in that case, had filed an application for the Supreme Court to take it up, I think over a year ago, and it's
Right.
still pending. And she points out that there are 40 other cases dealing with this issue or similar issues. Again, the substantive issue being the parents' rights to know from the school district what's going on with their child's education and what the child is telling teachers. That right, and whether or not the school district has an obligation to let the parents know when the child says something that indicates to the school district that the child might be at risk. And I'm making it a much broader category, but it's more specific to the gender issue with respect to Mirabelli and the Ludlow case, and presumably the other 40 cases that Justice Kagan refers to in her dissent. So that is a long-winded answer of what form is, jumping the line, as opposed to substance, whether or not the parents' due process rights or the teachers' due process rights are being violated by this California regulation.
And and I appreciate you explaining all that, and I don't think it's lengthy. I think for my readers, it's and listeners, it's very important for have these facts. I think what the issue for me is, I think, well, first of all, I do think parents need to have the right to have an impact on their child's decision about the way they live. But at the same time, though, we have child abuse laws to protect children from abusive actions by parents because of the fact that they are not given the right to make that decision progressively over time and to have experiences that allow them to do things and to get guidance and support to continue to look at what they're doing and see how it impacts them and what their thoughts are about it, what their feelings are about it, so they then can make a decision. I think one of the things that bothers me is I don't like short decisions. Yes, I think that the Supreme Court announced to us in one sentence what they were going to do, and so then they did Dobbs. I don't like that kind of thing. I think that a court needs to have all the factual data in front of them so that they can then make a decision. And maybe I don't like what their decision is, but at least I feel more comfortable when all the merits that are a part of the case are covered and looked at, and we look at the law and so forth so we know it. So I think one of the things that I think is really important here is this talk about this is not a final opinion, but it is impacting some of these children. I trust the parents that are saying, look, I just want to be included. And if our kids are doing this, let me know. And we'll try to be supportive and whatever. The ones that I think fit in the let's protect the kids is extreme religious groups that do things that are not helpful. And unfortunately, as a therapist for 18 years and then as a coach and working with people all over, I've seen too many cases, at least about the LGBT, before there was a Q on it, community, that there was a lot of abuse and things that happened and rejection of kids that really had an impact on their lives. So I'd like to see a way we could negotiate and say, okay, here's how we're going to decide a protection for children, but then here's how we're going to decide how to resolve these issues with the parents. So I may be a dreamer, but that's what I think would be a great thing. Now, that's not what it looks like. So what is the all these statements in this case? I know it stays the policy that California had, but it's not a final opinion. So tell me about the legal aspects of it and what all does it take, and cover some of this, please.
Yeah, sure. First, let me start with the term you used a couple of times was abuse. And The other thing with the shadow docket is typically the decision is what's called per curiam, which means no particular judge is signing off on the part of the opinion that is the order the court enters. And in the per curiam opinion, it reads, the injunction also permits the state to shield children from unfit parents by enforcing child abuse laws and removing children from parental custody in appropriate cases. So the first thing I want to raise with you is the requirement or the injunction that was entered by the district court did not prohibit the school district from reporting parents
Right,
if they felt that these gender issues the child was dealing with touched upon or there was a indication to the school district of child abuse such that the district arguably has a duty under the law to
right.
report it to the appropriate authorities. And I'm not going to branch off on that and talk about, well, when exactly should a district report child abuse? Because,
No,
on
no,
both sides
no.
of that, you have subjective arguments about, well, the district should have said something but didn't, or the district shouldn't have said something but did. The simple point is that there are other laws out there that the injunction does not deal with that would allow the district in the appropriate circumstances to report what it views as child abuse.
Okay,
Now,
thank you.
going off from that with regard to the effect of this decision, I mentioned a case out of Massachusetts that Kagan specifically mentioned where it has an application pending before the U.S. Supreme Court. And I think that's a good example because the injunction entered in Mirabelli was only with respect to the California Department of Education.
Right,
Now, the Ludlow case out of Massachusetts was decided differently. There, the court decided that the district could continue with the practice of not informing the parents about the child's choice of gender pronouns to be used at school. And the injunction in Mirabelli has no effect on what happened in Massachusetts from a legal or precedential effect. However, if the Supreme Court were to decide it in full, you've then got what I talked about earlier as precedent. You would then
right,
have, even though the case had come out of California, if Mirabelli were a decision on the merits, that would then control what the school district in Massachusetts has to do, or what
right,
the school district in Illinois has to do, or, Wyoming or Texas, or pick a state.
right,
Uh,
right.
if it's decided on the merits, you get to all of that being decided. And that is another one of the issues with the shadow docket is this decision basically is for one case only. It is only for the Mirabelli case, and its effect is only on the California Department of Education and no one else. But, the concern there again goes to um, using this interim decision making process on an issue where if the court, or at least four judges on the court, are that eager to deal with it, they could have just accepted the application in Ludlow, taken this up on the merits, and decided it on the merits so that it would have effect on everybody. You know, it, I would say you can almost see the frustration in the words in Kagan's dissent. She says, a mere decade ago, this court would never have granted relief in this posture. And that goes back to the statistic I was giving you. Again, in the first 16 years of this century, you only had 8 applications. That's
Right.
applications. That has nothing to do with whether or not the court actually granted relief. Only 8 applications by the executive branch. And now it's happening almost once a month.
Right.
And in quite a lot of these cases, the court is putting its thumb on the scale before the case is fully decided. And that's really the concern is, just what you touched on. Well, there are multiple concerns, but one of them is just what you touched upon. Okay, we've got a major issue. There are, you know, 41, 42 cases winding their way through the federal courts on constitutional rights with respect to school district decisions on this issue. And rather than taking one on the merits that we have sitting in front of us, we're going to take this one. We're going to issue a shorter opinion that really doesn't go into the merits of everything. I'm not going to call it slapdash, but a shorter opinion that doesn't fully go into the merits to at least telegraph to everyone what a majority of the court's going to do in less than 6 pages.
Right.
On an issue this weighty, and arguably it's like, well, at least we got 6 pages this time, as opposed to
Yeah.
one sentence or 6 sentences. But that's the shadow docket issue, or one of several shadow docket issues. And again, with regard to the effect of this case, that's just it. Who does this affect? The California Department of Education, the California Attorney General, and the parents, and actually only the parents in California, because the interesting thing is the court didn't only granted the injunction in part, or allowed the injunction to remain in effect in part. I don't know if it's because they just don't take on the issues the teachers raised, or the teachers did not bother to jump the line and ask the court to weigh on this issue. I did not look into that aspect of it. But what I do know is that the 6 pages, the court says, the application to vacate the Ninth Circuit stay presented to Justice Kagan and by her referred to the court is granted as to the parents, but is otherwise denied. So what
Right.
about the teachers? Um,
Yeah,
and then
and one,
I don't know
yeah, and
why.
yeah, and Richard, I think one of the things that really bothers me, and I think you've addressed a lot of it, is what is the Supreme Court's upset? We know the Supreme Court is very conservative. We know it is. It's it's
And it is.
amazing that it ever made the tariff decision, truthfully. And but I think the Ninth Circuit Court in California is probably not conservative. So it's almost like, let's grab this before the Ninth Circuit Court gives anything opinion that has merit, because then we're going to have to deal with the merit. Now, to me, if the Ninth Circuit Court in California deals with this issue and looks at the merits, and they do make a reasonable decision, yes, then those individuals that want to be more conservative and have their religious views that interfere sometimes with their making decisions, they're going to have a challenge. So, that's what but I would love to see what the Ninth Circuit Court will do.
I'm interested to see as well, but I will point out on this, I raised it earlier and I'll go back to it. If we're going to use the per curiam opinion in Mirabelli on this interim relief on the injunction, and the concurrence and the dissent to predict what the court is going to do on the substance, it looks to me like this very well will be an issue that crosses the so-called party lines, because again, Justice Kagan's opinion was joined by Justice Jackson, and as I pointed out to you, she seems to believe that the parents do have what's called a substantive due process right
Right,
to
right,
know important issues like these about their children. The parents have this right to be involved in the education of their children, and in particular, if you're dealing with issues that require um, medical care, psychological care,
right,
therapy, um, the appropriate um, the appropriate measures to help children deal with these issues, then it seems to me that the parents' right to know is not something that is Republican or Democrat. And this
Right.
very well could be a unanimous opinion, or actually, it's one of these like the tariff case. My guess is that perhaps eight or all nine of the justices will agree that the parents have a right to know. But what you'll have is you'll have five justices that say, uh, not letting the parents know violates their First Amendment freedom of religion right. And then you'll have six of the justices that will say doing this violates their substantive due process rights. And you'll have a bunch of different opinions talking about why this is or is not a violation of one's First Amendment right to the practice of, the freedom of religion, when in reality, all we're talking about is letting the parents know that your child prefers gender pronouns different from their biological, makeup when they were born.
Assigned. Yeah.
You know, where where that is in the Bible, I don't know. I'm not going to claim to be a religious scholar, but the court has precedent to say, well, that's a violation of one's freedom of religion. And then there's the substantive due process right, which the concurrence by Justice Amy Coney Barrett touches upon that. The per curiam opinion really focuses on the freedom of religion, which is not substantive due process. It's in the First Amendment. And then Justice Barrett, Justice Roberts, and Justice Kavanaugh say, well, yeah, we think it's a substantive due process issue as well, which leads me to believe that at least five, maybe six of the justices see it as a substantive due process issue when it comes on the merits. But again, what we've got not quite 18 pages, print on 18 pages, but the totality of the print is maybe 16 and a half, 17 pages where you're kind of telegraphing where you're going to go on these issues. And maybe I'm reading it wrong. Maybe we're all reading it wrong. But
Well,
it seems to me that this is not something that's really going to be the parents' right to know is not something that I think is going to cut cleanly on political lines.
right. And
I would
and
think that if you ask a registered Democrat, would they like to know, what their child is doing in school? The answer is going to be yes. And that's a broad question. But if you ask a registered Republican, would you like to know what your child is doing in school? The answer is probably going to be yes.
yes, and I think
Same as
that's the
independents and libertarians, I would say.
yes, and I think that that's going to be true. But I think if they allow the Ninth Circuit Court to do it on merit and let's see what happens in that court case, then we may have much better information because there are 40, if put Massachusetts in there, we've got 41 cases that are dealing with this issue. I'd rather see something of substance before it comes to the court, and that's the reason I dislike this.
And
I do want to, I would like,
you and numerous constitutional law scholars, and clearly Justices Kagan and Jackson. Yes.
right. And so, what I want to say though, Richard, is the reason we're doing this is because it is time for the American public to understand what is happening in the court system. They are the one branch of our government that is attempting to make decisions that are not always politically oriented. And so we're having a situation here where we have to understand what the courts are doing now. Now, as a past therapist and now as a coach, because I do a lot more coaching with this, I would like for my listeners to understand that if a child has gender dysphoria, it doesn't mean it's a lifetime mental illness that's going to destroy their lives. As a therapist, I've worked with many people that had questions about gender and allowing them to have a thoughtful, compassionate, and understanding process of not naming what they decide. These individuals progressively, whether they were children or whether they were adolescents or whether they were adults, over a time period, and particularly longer with younger children. But as had the ability to just simply look at all the aspects of their lives, they were able to make some very good decisions. Now, I think my listeners do need to understand that with the political attacks on the right to talk about gender, we have really created a negative environment for children, adolescents, and adults to look at their gender and make decisions. And I think I know from the lifetimes I've seen of people that have made different experiences based on their assigned sex. There are many of them that have been, they're much happier today than they ever had. Now, yes, there are some that had difficulties. I just want to summarize, though, what it says in the DSM-5 of our therapy statements about various illnesses that are named. It's saying that if a person exhibits 6 months of duration of any of the following six items, then we have to determine what kind of treatment and process and how can we help this individual come to a comfortable decision. And this is the first one, a strong desire to be of a other gender or an insistence that he or she is the other gender. And that is one of the comments. In boys, assigned gender, a strong preference to cross dress or use female attire, or in girls, assigned gender, a strong preference for wearing more traditional masculine clothing and a strong resistance to wearing the traditional female clothing. Another thing, a third one is a strong preference for cross gender roles in making a belief play or fantasy play. And let me say something. Young children go through all kinds of things. And I'm thankful for the parents that someday one of the kids ends up going to the mother's closet and decides to wear some of the stuff. It doesn't mean that they're in gender dysphoria. It means they're trying something out. And then the next day they may do something in their father's closet. So this is what I think is important. Another thing is strong preference for toys, games, or activities that are, a different gender from what they are. A strong preference for playmates of other genders. So a male may prefer women more, girls more, or girls may perform if they want to be of a male gender, then they prefer a male. It goes on into saying they may avoid certain games and activities that normally they would participate in, and a strong dislike and for any defined sexual characteristics that they have because they are in conflict with what they were assigned. Now, I think these cases are going to have a long discussion because we do have to protect the children from abuse, but we do have to respect the parents' rights to know. And how do we do that? And I taught school for many years, and I had to talk to a lot of parents about a lot of behavior because we didn't have a procedure like California has. But I think through that process, I helped the children and the parents to come to reasonable decisions about what they could do over time. So I think you've done a fabulous job in describing this case. I thank you very much every month for taking that initiative and using your legal mind to help us understand it. Is there anything else that you would like to say before we end this particular podcast?
Yeah, I've got reflections on two things that I'd like to share. And one
Sure.
you pointed out that you do not like the shadow docket and that people need to know what our courts are doing. And while I have a general dislike for the shadow docket as well, I will point out, at least going back to the executive branch increase in applications, that while I think a lot of the responsibility lies with the Supreme Court in wading into areas that, as Justice Kagan put it a decade ago, we would not have gone, I think the other issue has to do with um, failures of the other branches of government as well. The
Correct.
reality is we have a lot being done, like trying to use the National Guard to enforce immigration law, that I
Right.
don't think prior administrations and prior presidents would have dared try to do. And the same is true with regards to trying to use an abstract reading of a law to cancel billions of dollars in student debt because of COVID. I think that some of these applications come about because the executive branch has shown a greater propensity over the past 10
Right.
years to wade into waters it never would have gone before. So the point I'm making is that there are other people that can be blamed for the increase in applications and the increase in decisions on the shadow docket. I want to raise that issue, but in doing so, point out still a large portion of the blame, the majority of the blame, lies with the U.S. Supreme Court itself. The one other thing I want to touch on, because I mentioned it several times, and it is a legal issue that probably deserves more than 5 minutes, but just so that your listeners can understand a little better, I referred to a term called substantive due process.
Right.
And in Justice Barrett's concurrence with the order of the court, she points out that substantive due process is not dead or dying, as Justice Kagan seems to indicate in her dissent. And the idea of substantive due process, the way it came about is you have certain liberties that are specifically defined in the Constitution and the amendments to the Constitution. But then you have other broad categories where a specific right is not defined in the Constitution, but the United States Supreme Court has chosen to recognize it. For instance, the right to liberty includes the right of parents to know about and be involved in their child's education. Um, and the problem here comes with, okay, how fine are we going to split the hair to decide that this is something that the Constitution protects under the substantive due process rights or not? And the example I would use here is that broad category with regards to education. You would say, okay, that is a long recognized historical right, even though it wasn't specifically enumerated in the Constitution. Going back to the Articles of Confederation before the Constitution was around, parents had a right to know how their children were being educated. In fact, Justice Barrett says as much as her basis for saying that this is protected under the Constitution's substantive due process rights. But in regards to splitting hairs, I would then point out that a prior substantive due process right that apparently ceased to exist is the right of a woman to make
Right.
decisions about her medical treatment. Now, defined broadly, I would argue that that is a historically recognized right that women possess and that men possess that goes back to and predates the Constitution. But when you want to announce the right, not as a right of the woman to make decisions about her medical treatment, but the right of a woman to get an abortion, well, it loses that historical effect because of how thin we split the hair. We're
Right.
talking about a medical procedure that I don't know. Maybe it did exist in the 1790s. Maybe it didn't. I'm not a doctor. I don't know the medical history behind it. But the point I'm making is splitting the hairs and the manner in which different justices decide to do it is ultimately what gives rise to or the prevention of a substantive due process right. And what Justice Barrett's concurrence points out is, look, the court hasn't done away with substantive due process rights. She doesn't say as much, but even though Justice Thomas wants to do away with those rights, you've still got three of us Republican judges that believe those rights exist, along with the three liberal or Democrat appointments to the bench. So six of us still believe in substantive due process rights, and at least six of us probably believe that those rights allow the parents to know decisions like this being made by their children and by the school in relation to their children. So
Right.
again, that was 5 minutes on substantive due process, a topic that probably uh, is taught as an entire semester course in some law schools, but at least hopefully that 5 minutes gives your listeners enough of an understanding of what we're talking about when I mention substantive due process. And that is a right that is not specifically spelled out in the Constitution, like press or religion or bearing arms, but that nonetheless courts have recognized over the years as being within the scope of life and liberty and other things that were set out as being protected in the Constitution and the Declaration of Independence before it.
Thank
Okay,
you. And no, and I'm extremely grateful because I wanted to have you do substantive due process because I think it's so important. There is one thing that's coming to mind that where in Kagan's dissent did she make some comments about due process? Because she said, the parents have the right, but somehow the way she wrote it and brought up Dobbs, for a moment, I thought to myself, is she saying if you make a decision about substantive due process in this case, how can you make a decision about substantive due process that's related to women and their right to choose their medical treatment? Because when I was reading the case, that was what was happening to me. So,
yeah, and it's again, my focus, at least on this case, was the very first paragraph of Kagan's dissent, where she says, the decision shows not for the first time how our emergency docket can malfunction. The jumping the line. But what you're referring to, I believe, is what she discusses on page 5 of her dissent, where she points out um, that substantive due process certainly appears by members of the court's majority to be under attack. And she says the due process clause, needless to say, does not expressly grant parental rights of any kind. And then she says members of the majority have expressed skepticism, sometimes outright hostility, to understanding um, the capacious term liberty to enshrine specific undefined rights. And she mentions several opinions by Justice Thomas where he's arguing we need to do away with substantive due process rights. And a lot of people have pointed out that if you do with that, you really want to, if you want to do that, you really need to consider all of the things that the court has granted us under the broad umbrella of substantive due process. For instance, the Virginia case permitting interracial marriage
right.
was deemed to be a substantive due process right. Justice Thomas is married to a Caucasian woman. Oberfell v. Hodges, the case decided about a decade ago, telling states that you have to recognize same-sex marriages that have been performed and licensed in other states. That is a substantive due process right. So there are certain decisions, arguably groundbreaking decisions, that have fallen under the term substantive due process, but you've got at least one justice on the court that believes we need to do away with it. But beyond that, she also points out a decision by Justice Gorsuch, where, as she puts it, he refers to the misuse of the substantive component of the due process clause, which is not saying, hey, we need to do away with it altogether, but we need to put parameters on it and really limit when we use this particular legal concept to recognize rights that are not specifically spelled out in the Constitution. And she raises another comment by Justice Kavanaugh indicating the same thing. And, I would point out that Kavanaugh is one of the three justices, along with Barrett and the Chief Justice, that are join that are part of Barrett's concurrence. It was written by Barrett, but the Chief Justice and Kavanaugh joined that concurrence. So again, while Thomas may want to do away with it entirely, she's pointing out that Kavanaugh and Gorsuch have said things in passing in other cases that would indicate that they think substantive due process needs to be more narrowly defined. The concern by probably all of the justices is that uh, it would allow five members of the court to start defining constitutional rights that aren't specifically set out, in black and white. So, a lot of these legal principles can and often do cut both ways depending upon what side you're arguing. For instance, with, the right to know, or some of the substantive due process rights we've discussed today, okay, some states have outlawed gender transition surgery. Well, if a right to make medical decisions is a substantive due process right, is a decision by, say, the state of Alabama to prevent me from obtaining a gender transition surgery, is that a law that violates my substantive due
Right,
process right
right.
when we remove it from the parent's right to know in relation to education and apply it to my right to make medical decisions when we're not talking about the life of an unborn child or fetus being something that is weighed in the scales? Again, it can cut both ways. That's just a hypothetical I pulled off the top of my head.
Yeah, but I think it's very helpful. And I appreciate your examples because I think it gives more clarity. And so we need to start paying attention to the what courts are doing, and we need to speak out about the things that we do not support, and we need to speak and be supportive of some of the things they're doing and some of the questions they're bringing up. And I am very appreciative of you doing this with me for a podcast once a month because I think yours and my purpose was to say, let us try to give you some knowledge base, some experience, some education about what is going on in the courts. Because I don't think we've talked about it enough in America about how important the courts are. And I've always believed, many of my friends laugh because I say some of my best friends are lawyers. And then they say, and they laugh about it because I have great respect for the legal institution, for the rule of law. So I want to thank you for being on today. I look forward to seeing what we're going to do in the next one, because this one has been expanded my knowledge and my mind about what the legal aspects are of a court, and that's what I think is really important. So thank you so much, Richard, for being on.
My pleasure.